Hi, and welcome to Holland Estates. I'm Paul Trudelle.
And I'm Christina Canestraro.
And you're listening to episode number 572. How are you today?
I'm doing well. How are you?
Very good, thanks. Today we thought we'd spend some time talking about a recent case that came out of the Ontario Superior Court of Justice. It's the case of Cavanagh and Sutherland. It's a decision of Justice Spire, and it deals with a number of great issues that I thought we would spend a little time discussing. Deals with, it's a motion for summary judgment. It deals with whether you can bring a motion for summary judgment in an application where a trial of an issue was ordered. Deals with the test for summary judgment. Deals with a novel concept of law on which you can challenge a will, and we'll get into that, but it's a material mistake of fact and whether that gives you grounds for challenging a will. And then it looks at the facts and whether there was, in fact, a material mistake of fact. So maybe you can just give us a bit of background as to what got this case to court.
Sure. So to give you a little background on this case, so in this case, the deceased's name is Joan Cavanagh. She has 6 daughters, Carolyn, Catherine, Diane, Angela, Christine, and Ruth. So in her lifetime, she drafted 4 different wills, one in 2001, one in 2006, one in 2011, and one in 2014. So the 2001 and 2006 wills are not contentious. She left everything to her husband, and if he survived her, and if he predeceased her, then everything was to her 6 daughters equally. Things changed in her 2011 will. In that will, she left everything to her husband, and if her husband predeceased her, then everything to her 5 daughters, although she excluded her daughter Carolyn in that will. And in her 2014 will, which was similar to her 2011 will, she left the residue of her estate to her 5 daughters and excluded Carolyn. At this point, when she drafted her 2014 will, her husband had passed away. What happened was, in her 2014 will, she had 3 of her daughters named as the estate trustee, so Catherine, Diane, and Angela. And so shortly after Mom died, which was on July 31st, 2016, the 3 daughters bring a certificate of appointment of estate trustee, or an application for certificate of appointment of estate trustee with a will to the court. And Carolyn files a notice of objection to the issuance of that certificate of appointment of estate trustee on the basis that her mother disinherited her in her 2014 and 2011 wills. Initially, she had brought the objection based on lack of capacity, suspicious circumstances.
Undue influence, suspicious circumstances, the usual grounds upon which we bring a will challenge.
Right.
So there was the application then for directions, and the directions were made with respect to mediation, examinations, and the trial of an issue.
They set up timeline, for how the application was to proceed. That's right.
But before it got there to the trial of the issues, the estate trustees brought this motion for summary judgment.
That's correct.
To deal with the objections raised, and their position was that the trial wasn't required, and they can be dealt with by a judge on a motion for summary judgment.
Exactly. And interestingly, actually, when Carolyn went to submit her factum for her cross motion against the motion for summary judgment, the only basis that she was bringing that on was for the material mistake of fact. So she was alleging that her mother had made a material mistake of fact when she was drafting her 2014 will, and if that was invalid, then the court would have to look at whether the 2011 will was also invalid on that basis.
Right. So the issue that the judge dealt with was the material mistake of fact argument on the motion for summary judgment. And it's important to I guess, note that the judge here considered the allegation of material mistake of fact and whether that was grounds for setting aside a will, if there was a material mistake of fact.
Right.
And the judge didn't conclude that that was a ground, and acknowledged, or counsel, in fact, acknowledged that there was no case law or precedent for that argument.
That's right.
The judge did say, however, that the judge wouldn't get into that issue because the judge felt that there was no material mistake of fact.
Right.
So it left that argument as to whether that's a ground for challenging a will to another day, because the judge just didn't have to deal with that issue.
Right. That's a fight that'll have to happen another day, another time.
Yes. So that's the door may still be open, although
Right.
it's not clear how wide open or how big that door is.
Right.
Maybe we can talk a bit about the allegation with respect to the material mistake of fact. What was the mistake that Carolyn alleged, and what did the judge conclude with respect to that issue?
Yeah, certainly. So essentially what Carolyn was alleging was that there was a payment made to her of $65,000 back in 2011, and she was alleging that the payment was made to her as a repayment for a loan that she had given to her parents. And so the judge assessed the evidence before her and essentially had to make a determination of, oh my gosh, sorry, is it him?
No, it's fine. I didn't mean to interrupt you, but I was thinking that what the deceased said in her will was that I didn't give anything to Carolyn because I have made, in my view, adequate provision while I was alive.
Right.
And Carolyn said, well, no, she didn't make adequate provision for me. She didn't. This $65,000 that she gave to me wasn't a gift or provision. It was in fact a repayment of a prior loan.
That's right. Yeah.
So the judge then goes into look at the circumstances surrounding that payment and whether it was a repayment of a loan or whether it was in fact a gift.
That's right. And in her analysis, she relied on the evidence, affidavit evidence that was before her. So when she was making that determination, essentially what she did was she looked back at some correspondence between Carolyn and her parents and between Carolyn and her sisters around the time that this $65,000 payment was made. What the judge found was that in 1996, Carolyn's father, Richard, needed money. Her mother, Joan, owned a cottage, and she was going to get a loan against the cottage in order to provide this money to her husband, Richard. And so the loan was going to be secured against this cottage property. However, she couldn't get the loan alone. And so what she needed was her daughter, Carolyn, to be registered on title to the cottage property in order to secure the loan against the cottage property. And so what she did was she transferred title in the cottage with Carolyn jointly. And there's a little point of contention on whether the transfer of title was meant to give her a beneficial interest in the property or whether she was simply on title just to secure that loan.
Right.
Yeah. Basically what happened was eventually in 2011, Richard and Joan, their circumstances changed and they were able to pay off the mortgage on that property. And so they started writing to Carolyn to request that she transfer her interest in the cottage property back just to Joan or to Joan and Richard jointly. And so Joan and Richard had their lawyer write to Carolyn to advise her that there was never an intention to provide her with legal title to the property and that she had not paid any mortgage payments or provided funds for maintenance or upkeep of the property. But despite this, her parents were willing to pay her $25,000 in order to transfer title back to mother and father. And so in response, what she said was that she was intended to have a legal interest and that based on the value of the property, she was potentially in to receive $200,000. So the $25,000 was unsatisfactory. And if they wanted to pay her back, they could give her $75,000. And so this went back and forth for quite some time about how much money Richard and Joan were to pay her.
I guess the issue there is whether Carolyn felt she had to be bought out because she owned a piece of this cottage. The parents didn't think she had to be bought out because it was never hers and she was only put on so they can get the mortgage. They ended up giving her the money.
They did,
The correspondence from Carolyn or between Carolyn and her parents at that time never made any reference to the repayment of a loan.
It did not.
It was just a payment that they felt they had to make to her in order to get the cottage back.
That's right.
That was what they felt was the provision to them.
Right.
And the judge looked at the surrounding correspondence and circumstances and correspondence between Carolyn and her sisters and concluded that that wasn't really a loan and there was no mistake of fact on the part of the mother. The mother did give that money to Carolyn.
Exactly. And since other legal issues like capacity were not alleged at this point, the judge didn't have to look at whether, there was some other
Right.
legal issue surrounding whether the payment of $65,000.
Right. And just to buttress the estate's argument, there was later on, Carolyn went and asked her mother for some money to help out. That was a loan to Carolyn.
Right.
And Carolyn actually paid it back, and the judge said, well, if Carolyn was owed money, then
She would
he
have
would have said
referenced
that
it.
at the time.
That's right.
So the judge felt that on the evidence before her, then that it was necessary to have a trial and the matter to be dealt with summarily.
Exactly.
Okay. So the judge also talks a bit about whether you can bring a motion for summary judgment where there is an application. The highlight of that is that in this case it was converted into a trial of an issue which was akin to an action, and therefore summary judgment would be appropriate.
Right.
I guess another route to take would be to just leave it as an application and have it heard as an application on documentary evidence alone.
Exactly. Yeah. I think the reason why the judge also said that it was able to proceed by way of action was because it was specifically stated in the order giving directions on August 8, 2017, that any disputed issues be resolved at a trial. And so the judge said this is effectively a direction in accordance with Rule 38.10 of the Rules of Civil Procedure that the proceeding be treated as an action. So she found that to be sufficient in order to treat it as an action.
Yeah, and the judge referred to just the expeditiousness and proportionality in order to allow the matter to proceed by way of summary judgment.
Exactly.
On the issue of costs, Carolyn it was found that she would be liable for costs, but
That's right.
At what level hasn't been decided yet, or not that we're aware of anyway.
Not yet. Yeah, exactly. Not that we're aware of. Yeah.
I think that brings us to the end of the podcast. We'll put a link to this decision on our website, and we want to thank you for listening. And I'm Paul Trudelle.
And I'm Christina Canestraro.
And if you want to ask a question or leave a comment, please email us at webmaster@hullandhull.com or leave us a comment on our blog page. Thank you.